The Americans with Disabilities Act Overview. Introduction. Disabled Americans constitute one of the largest American minority groups coming under the category of special population. Even though disabled people have physical limitations, they often argue that they can do any kind of job handed over to them by employers with equal efficiency. The exact number of disabled people in America is around 50 million. This group also has the highest unemployment rate in the country, almost 70%. Their skills and abilities to perform a job are somewhat ignored by others. A prominent nonprofit group working in America for disabled people stated that it was important to point out that people with disabilities are just people. These people have their strengths and weaknesses like other normal people that will enable them to perform normally at the workplace. Main body. Recent studies also revealed that nearly 90% of people with disabilities are above the average when compared with the general workforce that is available. Additionally, people with disabilities represent $1 trillion in the yearly aggregate or total consumer spending. One of the most significant developments that were brought by globalization was concerns regarding the supranational expression of rising community movements and political programs. Disabled persons had to stumble upon the international arena as a crucial space for dialogues to maintain their rights towards social incorporation, equivalent chances, and non-prejudice. Disabled persons were excluded from normal societies. Oppressive cultural values were often attached to them. In this scenario, there was a need for an apt legislation that could help these people overcome these exclusions and prejudices. Moreover, sufficient resources must be made available to ensure the expansion of proposals that are receptive and approachable to injury, and ethnic and cultural diversity within the disabled inhabitants. Importance should be given to the choice of the individuals. Self-determination issues of disabled people should not be merely linked to service delivery mechanisms but should be checking the sufficiency of resources that are necessary for the delivery. To protect the rights of disabled people, the American government passed the American Disabilities Act in 1990, later it was amended in 2009. This act prohibits discrimination against disability in society. The amendment made to the act in the year 2009 gave wider protections for disabled people. Title I of the ADA of 1990 stops private employers, state as well as local governments, various employment agencies, and labor unions against discrimination of qualified people having disabilities from job applications, hiring, compensations, training, other terms of employment, privileges, etc. The coverage of this act works when the employers have 15 or more employees. The ADA is also applied in the federal sector under Section 501 of the Rehabilitation Act. As per the provisions of the Act, a disabled person is defined as a person having a physical or mental impairment that critically limits one or more major life activities. The Act also extends its definition by quoting that a person is regarded as a disabled person if he has a record of such impairment or is regarded as having such impairment. According to the Act, a qualified applicant having a disability with or devoid of reasonable accommodation can perform the necessary functions of the job. The employer should take reasonable steps to make a reasonable accommodation to the known inability of an applicant who is qualified as disabled. According to the Act, reasonable accommodations are adjustments or changes that are provided by the employer to enable persons with disabilities to enjoy equal job opportunities. The Act specifically states that the employer is not required to bring down the quality of production or standards to make accommodations. The employer is also not responsible for providing aid for personal use. Title I of the Act also covers medical examinations and inquiries, drug and alcohol abuse, upkeep of confidential records, etc. The ADA also makes it clear that it is quite illegal to hit back against a person for contrasting service practices that differ based on disability, for filing a favoritism charge, or to give evidence in an investigation under the ADA. The ADA protects the civil rights of persons having disabilities. This protection provided by the ADA is parallel to those given to people based on the color of their skin, cultural race, gender, nationality, faith and religion, and age. The ADA promises identical chances for people having disabilities in transportation, public accommodations, job vacancies, telecommunications, government services, etc. Conclusion. The ADA is a disability-related law that is familiar to many American people having a disability. This act is better known than any other act in this area. This is because this act applies to organizations, businesses, and a wider range of individuals. The Equal Opportunity Commission has the first responsibility for enforcing the ADA under Title I, and the Department of Labor's Office of the Federal Contract Compliance Programs has coordinating authority of this law. Title I of the American Disabilities Act bars employers in the private sector who employ more than 15 employees as well as labor agencies, employment agencies, and management committees from discriminating disabled persons in the field of employment. Title II of the ADA prohibits discrimination based on disability and imposes positive disability-related responsibilities on civic entities that include state and local governments.